Okay, why don't we go to the and at the next slide, and the link to the order has been posted in the chat box. Okay. We get to the next slide. There's the website, and now we're can we display the Q&As? All right. Thank you, Nate. So we'll just go down the Q&As. We did have some updates, particularly towards the end. And so we start out with just where the 8th public health order is, who is subject to the vaccination requirements, who's responsible to notify the contractors, and then, our contractors responsible for paying the test, no, the state's not going to reimburse, pay those for testing, and the state will not pay for the or the PCR testing is preferred but not mandated, and then certification. And so November 10th, the dates that's coming up, the contractors must complete and submit their certification back to the government entity. And if they do business with multiple entities, then they would submit multiple forms, for each of the government entities. And there are exemptions in the next question for medical and religious. And the state is not allowing extensions from the exemptions for the public health orders. So these questions pretty much stayed the same from where we were last month. Let's move on to the next group of questions. Thank you, Nate. So the next question goes into how a contractor would obtain a medical or religious exemption. And this is the responsibility of the employer. So the employers would be creating their own policies for the receipt and review of those medical or religious exemption requests and informing their employees of their determination of that medical or religious exemption. And in terms of showing proof of medical or religious exemption, the state contractor would keep track of who they have approved for exemption. And the state contractor shall identify those employees by name. That's all in the public health order. And the government entity may request a copy of that list of employees that have been vaccinated or have an exemption. And the contractor employees should carry documentation of the approved exemption and documentation of the twice weekly testing with them. The consequence for a state contractor that is non-compliance with the public health order, in that case, the state contractor would be non-compliant and enforcement remedies would put in place as provided in the public health order. And the state agencies may exercise remedies available under contract, and that would include, as many of you know, up to and including termination of the agreement. Next question is, as a contractor, how can I certify that my employees with access to state facilities are vaccinated and participate in twice weekly testing? And that's up to each state contractor. They need to decide how they're going to verify how their workers are vaccinated or whether they're exempt and testing with the complying with the testing requirements. If State contractors would work with their human resource partners to request, verify, and maintain vaccination, exemption, and testing, and of vaccination and testing information. And then the last one on this page is do contractors have to maintain a list of employees? And yes, as noted before, and this is actually again in the public health order, the contractors do have to maintain that list and update that list. So let's scroll on to the next set of questions. All right. Can a state contractor employees be stopped and asked to show proof of compliance? And yes, they are required to maintain this information and provide the agencies with their attestations regarding their vaccination or testing status. So next one is if a state contractor comes onto state property, and examples there are state wildlife area and a remote area, garbage collection, fueling services, snow removal. Do they have to comply with the public health order and does not enter the building? And the answer there is an important one. The intent of the public health order is to capture entering into an enclosed structure, a state building with the purpose of providing services or goods. The public health order would not apply to these cases. So the key is entering into an enclosed structure. It's not entering the grounds of the structure, but it's actually entering into the structure. So if they're on the outside in the remote area or collecting garbage, doing fueling, snow removal, those examples in the question, the public health order would not apply. The next question is if unvaccinated contractor comes onto state property once a year, for example, a kickoff meeting, would they need to test twice weekly or that week or throughout the entire contract? And the answer here is that twice weekly testing is required throughout the contract term for any individuals who will at any point be entering a state facility. The next one is on regarding institutions of higher education campuses. Is the entire campus considered a state facility or just an individual building? And again, this gets back to one of our prior questions, that the intent of the public health order is to capture anyone entering into an enclosed structure. So state building and a state building with the purpose of providing services or goods. So the public health order would not apply or would not apply to the state contractor if they only had access to the outdoor portions of the campus. In that case, they're on the outdoor portions of the campus and the public health order would not apply. How about the next question on common space, where the state is only leasing a portion? In that case, the public health order would not apply to common areas like lobbies, elevators, restrooms, etc., or partially leased buildings in which the state has offices and shares a communal space with other businesses. And the last one on this page here is, for purpose of the public health order, do DNR state park visitor centers, state park shade shelters, and state park vaulted toilets qualify as a state facility? So the state park visitor centers, again, they're an enclosed space, are state facilities and are subject to this public health order. But shade shelters and vaulted toilets do not qualify as state facilities under the public health order. All right, we'll scroll up here. And DNR has a number of concessionaires who operate on state-owned lands, may have arrangements for concessionaire providing rents for paddle boards. Are these concessionaires buildings on state property considered state facility? Answer is no. Concessionary buildings and stands are not considered state facilities under the public health order. The next one are official function events in rented space like hotels, subject to contractor vaccination requirements. And no, those locations are not state facilities. Who's responsible for collecting the certifications from the contractors? The agency responsible for collecting the certification documentation And it's recommended to be saved as part of the contract file. There is not a central repository for certification documentation. Who's responsible to ensure the contractor's employees are in compliance with the public health order? And it is the contractor's responsibility to ensure that their employees are in compliance with the public health order. And this is the contract is certifying that the employees are in compliance, and the contractor is responsible for maintaining that list of the employees and their names who are required to access state facilities. And then I think we had this question or similar question before on multiple contracts. Do they need to send certification form of their contracts? And yes. Contractors must certify for each agency separately because each agency has no knowledge of what the contractor is entering into for another contract. What are the repercussions if a state agency misses a few contractors or fails to get all certifications? In that case, the state agency or the contractor would be in violation of the public health order. Does the state public health order apply to police, fire, and EMT services? No. This is for contractors, not emergency service providers. How does the public health order affect volunteers, the public, board members, grantees, and third parties that are not contractors? And the answer here is that the public health order applies only to state contractors. A visitor, volunteer, board member, grantee, or third party entering in state facilities not subject to the public health order, these individuals would need to comply with the requirements of the agency that they are visiting. Does the public health order consider individuals or entities that make donations of goods at a state facility or for a contractor or a state contractor worker? And no, the state public health order does not cover individuals or companies donating goods to the state. And does the public health order apply to janitorial services provided by a landlord pursuant to a lease agreement? And yes, landlords and their subcontractors are considered state contractors in the public health order, including janitorial services that are provided to the entire lease building, including tenants, not just the state. And then are individuals who attend public meetings and events at state facilities subject to this health order? No, this public health order applies only to state contractors. It does not apply to volunteers or individuals who are not state contractors or state contractors. And then how does this affect students? Students are not state contractors for the order, and so this does not apply to them. All right, should agencies amend current agreements with contractors' requirements of the public health order? The requirements of the public health order are legally enforceable and are independent of state federal, state and laws and rules, regulations, including laws applicable to discrimination and unfair practices. So that's right in our special provisions. Can agencies send DPA provided notice letter to contractors without an individual name, address, contract number? Yes. And agencies may communicate this individual information to their contractors as they determine best for their agency. Next question is, if an agency leases space in an office building that is not owned by the state, is that office considered a state facility? And yes, a state facility does include lease space. Does the public health order apply to a state facility under construction? The public health order does not apply to a state facility that is under construction. It does apply for the renovation of an existing facility. For demolition or site work on an undeveloped state facility, is there a point in the construction project prior to acceptance that the structure qualifies as a state facility. The undeveloped site becomes subject to the public health order upon acceptance of a certificate of occupancy. And then the last question on this section here is, does the public health order apply to vendors that have a purchase order with the state? And the answer is yes. So it's all kinds of agreements. So it applies to state contractors and their entities that have accepted the state to do business with the state, and whether it's on a contract or purchase order or other agreement. So let's scroll up. Does the public health order apply? Scroll down just a little bit, Nate. I think we're going to miss one question if we don't. There we go. Thank you. Oh, we did get that one. I'm sorry. Okay. Does this public health order apply to contractors who enter a state facility that are not on a purchase order and small dollars less than 5,000? And yes, the public health order applies to all companies providing goods and services to the state that enter property of a state facility in any form of agreement, including a contract, purchase order, or a commercial card. Next question, and this section here is new from our last time that we talked. In fact, a lot of these questions came up in our first meeting. Are delivery companies such as Amazon, UPS, FedEx covered by this public health order? The intent of the public health order is to capture any state contractors who enter a state facility. Residential state facilities have a higher standard of scrutiny, and the intent is broadly written. If the delivery does not have a contract with a state agency, the requirements do not apply. Next question is, are there conditions such as emergencies where agencies can make exceptions, such as exigent circumstances like a roof leak, or when there is no patient or employee and no employee contact with the state contractor, such as immediately addressing a harmful building that would not require compliance with the public health order? So the answer here is the access to emergency responders as law enforcement, emergency medical services do not require compliance because they're not state contractors. And also for authorized emergency procurement to protect the public health and safety outside the contract, that would also not require compliance with the public health order. But note the however here, that if the state contractor had the work as part of its scope of work, then compliance for the state contractor would be required. So in other words, if that state contractor knew that the emergency was as such that they were going to be entering into the state facility and they're aware of this, they would be subject to the public health order. Okay, we got one more. OIT, contracts on behalf of agencies. Is the agency, or who is the agency responsible for following up and obtaining the certification? So the answer here is the agency listed as the party of the contract is the agency responsible for obtaining the certification. So let's scroll up. Got a few more here. Does this public health order apply to contractors that have signed a state contract? And as we noted before, it could be any form of agreement, contract, purchase order, commercial card. And then finally, how can tenants that operate a state facility and that provide services to citizens, where testing sites are 25 plus miles away and only operate 1 day a week, comply with the public health order that requires twice a week testing? So in this situation, the state agency should require testing that is available in the area. And in this case, once a week. And further, engage other partners, including CDPHE, to see if additional testing services are available. So that wraps up a very quick rundown of the Q&As. And so now we'll open it up for questions, and I think Nate, you can use the chat feature, or you can unmute yourself, but chat feature is preferred, so that we can capture all of your questions.
The first question is there a time frame in which negative test results must be within? So for the twice weekly testing results, what is that time frame?
And do you want to take that one, please?
Sure. I'm just trying to think about how to answer that question effectively. So the testing provider has a time frame essentially for which they would then process the specimen and provide a test result, and utilizers of that service can't really modify that time frame. So if you're going to a testing clinic that is, established as a testing clinic, a provider that provides those testing services, you would need to provide the result that you get through that testing service, or make that result available upon request as soon as you receive it back. So I can't say that you would need to provide that test result within 24 hours or 48 hours or 72 hours. You would need to continue to do the routine testing and receive results, however that provider ultimately, however their lab provides results back.
Thank you, Ann. The next question. If the landlord of a leased property will not attest, what can the state agency do? Is the state agency required to terminate the contract? Can the state agency legally bar the landlord from entering the leased property? What are the state's options?
Well, as we, thank you, Nate. As we noted in the Q&As, they're in violation of the public health order, and they are also in violation of the state contract terms and conditions. And so the state agency has all the remedies, contractual remedies that are included in the contract. So that would be up to the agency in terms of how they want to proceed, but they have various options there in terms of their contractual remedies when the landlord does not comply. And given the seriousness of this epidemic and the need to comply with the public health order, I would say I would lean more on the remedies that would include termination.
Next question. Just to clarify, do we need to get certifications from contractors that we have a contract with but will not be entering the state facility?
And if the agency is, I will say, as near certain as they can be, that the contractor will not be entering a state facility, then they do not need a certification. Again, the public health order applies to state contractors that are entering into a state facility. So if you are certain that that contractor will not, during the term of the agreement, enter into a state facility, then the state agency would not need to obtain a certification from that contractor.
The next question is regarding enforcement. So if vendors don't attest by next Wednesday, November 10th, what is the recommendation of the AG's office of DPA? Is there some language coming that state agencies should use to notify their vendors that they're not in compliance with the public health order? Should we notify them of termination? And how long should agencies wait to discuss termination with their state contractors?
And that's a great question. And we have Ann on the line as well. But my initial reaction would be that our first step, just as we do when we have I'll say a suspected or a potential breach of contract, we would provide a opportunity to cure. And so my first step, what I would suggest is that the agency send a letter to the non-compliant contractor saying you've passed our deadline November 10th, and you have X number of days to get into compliance. I'd want to talk further with Ann about that in terms of just what that would look like. And then if the contractor doesn't apply on that next time around, then I think we could start talking about termination, because then at that point, to me, it's more of a willful and a disregard for the public health order. And Ann, if you would like to add anything, please. And you're on mute if you have anything you'd like to add.
Can you hear me now? I was having extreme difficulty being able to
Yes.
unmute. Okay.
Yes, and we got you. Thank you for unmuting.
Okay. I agree with your assessment, Bob. I think we'd have to walk through it the first time this happens, and hopefully it won't happen. But yes, I think the notice of breach and opportunity to cure is absolutely the right way to go. As Bob had mentioned, there is the ability under the public health order as well to take enforcement action. But frankly, with your contract remedies, they are probably the most expedient and efficient way to deal with a potential breach of contract for failure to comply with the vaccination and testing requirements. And so, yes, we'd need to figure out exactly what the language would say, but if they're not in compliance and after given the opportunity to come into compliance, they fail to do so, I think you definitely have the potential to terminate that contract for that reason.
So thank you, Ann. So I think our takeaway at the OSC then will be, we'll develop a form letter. We'll work with Ann and have that available just in case we run into these situations. Again, hopefully we won't.
The next question is regarding commercial cards. Typically, a commercial card transaction is not considered a contract per se, but more a method of payment. Is there any additional clarity on how to implement this public health order regarding commercial card transactions that don't necessarily result in an agreement, right? For example, water delivery, food delivery, copy, paper delivery. So what if it's just a one-time, a 1-minute delivery by a vendor paid by a commercial card or P-card transaction?
Yeah, and I think it raises a great question. They're right in terms of the commercial card being a method of payment, but the end result of that is we've engaged a contractor to enter into a state facility, and in that case, and again, let's call it the entity then. But that individual or that company that's entering into the state facility is providing a service to the state entering into a state facility. So my take on it would be that the public health order would apply. And again, I know that we look at the commercial card as a method of payment, but the fact is that the end result of that is we've engaged a contractor to come into our facilities and provide services, and so subject to the public health order. And I would have a hard time saying, well, in that case, if it's a commercial card, it wouldn't apply, but if we issued a purchase order, it would apply. And that to me is a distinction that we really shouldn't be making. That the end result of that is that the individual, the company is entering into the state facility and should be covered by the public health order. And I'll ask Ann if she has any further comments on that question.
I don't. I agree with you, Bob.
Next question. PCR testing is the recommended and preferred method of testing for the state. Can you speak to any and all acceptable alternatives to accommodate state contractors?
I'll turn that one over to Ann.
I wish I had my laboratory testing staff on the line with me. I really am not the subject matter expert in terms of alternative forms of testing to be able to accommodate contractors. I would encourage, if there are questions in this realm from particular contractors regarding availability of testing services in their vicinity, that they reach out to CDPHE, and I can then work with our testing staff to figure out if there are other options that are equally viable.
Thank you, Ann.
Next question is a confirmation question. So if a contractor does not enter a facility often, can they perform system wellness checks during the periods when they are not entering a facility? Or do they have to have bi-weekly testing throughout the term of the contract?
So Nate, I take it that this contractor is, and we did have a Q&A on that they come into the building maybe once a year sporadically. And if that's indeed the question, then I think we have a Q&A on that says that the contractor would need to be tested during the contract period every twice a week. And Nate, did I capture, is that correct? Is that a correct interpretation of the question? I want to make sure that I answered it.
Yes, that's how I interpreted the question.
Okay, thank you.
The next question is, will the Office of the State Controller be providing a modified certification of COVID-19 vaccination template for agencies to collect from the new vendors or new contracts going forward that are now, the dates in the old templates are passed? That makes sense.
Say, yeah, Nate, I think we should be doing that. Our office should be doing that. So that's another assignment for us. But yes, I agree. We should be doing that.
Next question. Colorado Department of Public Safety, and I'm assuming other agencies as well, work closely with local law enforcement partners who are not necessarily under a contract to do so. Are the partners expected to comply as if they were contractors under the public health order?
So are the officers coming into the state facility then? Is that the question? And are they there for an emergency, or are they there like ongoing for security? I mean, it would depend. One of our Q&As says that if it's an emergency, no, that wouldn't apply. But if in fact they're more a security service and they're coming in every day or regularly, then I think the public health order would apply.
The next question is, if the work being done is for free or $0, and the worker is not subject to a contract or a PO or a commercial card payment, how should agencies draw the line between the worker that is considered a state contractor and thus subject to the public health order?
So you mentioned the question has a $0. Is this a volunteer? Is this, I mean, one of our Q&As, this public health order would not apply to volunteers. A contractor, I would think, would be someone who would receive compensation from the state and have a contract in place, or, as we mentioned, any of the other available forms, commitment vouchers. So I think that's the distinction that I would make, is if they're compensated and have an agreement in place to do services for the state.
And the volunteer is the example cited there. The next question is very similar. So in the event a state agency has a contract with the promoter to have an indoor event and the tickets are sold to the public, is it understood that we request compliance from the promoter and their employees and subcontractors, but what is the expectation regarding the public who are attending the event?
And this is held in a state facility?
Let's say yes, for the sake of the question.
Okay, so the public health order applies to contractors that enter into a state facility. And it would not, so that would apply to them. So the promoter in that case, in your example. But if the public were to enter, then they are not state contractors, and the public health order would not apply to them. The state contractor portion of the public health order would not apply to the public.
The next question is, how are agencies expected to track discretionary purchases that are made on a commercial card where there is not a central location necessarily for tracking those purchases or accepting delivery of any goods ordered on those services?
Yeah, this is another great question, and Sherry Maxwell and I met with the procurement officials, I think, a couple of weeks ago, and we heard this, and I certainly heard the concerns from the procurement officials. But we do have a public health order, and we need to comply with it. So in this case, I think perhaps the best approach, or one approach, could be that the agency make their commercial card holders aware of the public health order and when the public health order would apply, and just put the individuals that are using the procurement card to enter into agreements or situations where they're having contractors come on site, that they made aware of that, and that they then work with the vendor who's providing those services to comply with the public health order. I know it's a very difficult challenge for any agency, and certainly when we have cases like that for the procurement card and the very widely distributed users of procurement cards, and the widely distributed goods and services that they buy, and the widely distributed reconciliations and identification of these situations. So I think in that situation that agencies should do their best to communicate the requirements of the public health order. And again, we want to try to do our best to comply. It's a very serious pandemic, and we want to try to avoid those situations where state contractors enter into state facilities, particularly those one, as we mentioned in our public health Q&As, the residential areas that are not not complying with the public health order. We certainly would want to have that situation. So So that's how I would address that situation. And I know it's going to be challenging for the agencies to do that with procurement cards.
Bob, that was the last question I have in the chat, unless I have missed any.
Okay, Nate, thank you very much. Ann, do you have anything that you would like to add?
Thanks, Bob. I just want to go back to one of the questions to make sure we're all on the same page. So there was a question about the Department of Public Safety working closely with local law enforcement. But I think the critical piece of that question was not necessarily under a contract to do so. So I think the focus in this conversation and clearly the focus of the public health order has been on applying the requirements of the public health order only to state contractors. So I would say in response to that question that those law enforcement partners that are not under a contract would not need to comply with the requirements of the public health order. But I think Bob's example was exactly right. And that is, if it's private security, if it's someone being brought in under a contract or a purchase order or some other state agreement to provide services, then they would need to comply. So just wanted to make sure we were clear on that point and see if there are any follow-up questions based on that.
Thank you, Ann. Appreciate that. Any other questions, Nate? Anything else in the chat box?
No, Bob, no more questions in the chat box. If you would like to ask your own question, I can unmute you as well. Any requests? Well, Bob, I have no requests for questions. No additional
Okay.
questions.
Okay, well, I want to thank Lisa Trujillo for running the show here today. Certainly Nate and getting all these Q&As together and lined up for us. And then Ann House, you're always welcome and added a lot to today's call as well as our prior call. So thank you. Thank you for your participation. And then certainly thank you to all of you on the phone. Again, the public health order is very important and I appreciate your attention to this. What we'll do is we'll take your Q&As, we'll update them and we'll get them back up on our website. So thank you all, and we'll be signing off. So with that, everybody have a great day, and we'll be, as I say, updating our Q&As. Thank you all. Bye.